Welcome to Case by Case. This is a podcast brought to you by Calum, Cheyne and Luke Zadkovich. I'm Luke. Calum, how are you?
I'm good. It's been a little while since we did one of these. It's good to be back on.
It is. I think we remember what to do on this. And today we're very fortunate, Calum, in that we've got a guest to help us through. We've got Paul McMahon with us. Paul, welcome.
Thank you very much, Luke, and thank you, Calum, as well. I am an avid listener of the podcast, and it's a great privilege to be on it.
It's fantastic to welcome you. Yeah.
Yeah, I was saying it's a privilege for us to have you on because certainly I know a lot of my peers and colleagues and clients are big fans of your LinkedIn posts. I think you've done a very good job of capturing the kind of interest, the commercial interest, the legal interest, in very succinct and digestible updates that seem to go over extremely well. So it's great to have you on the podcast.
Thank you. And in a sense, this podcast is only happening because I've started doing these LinkedIn posts really back in December. It's not very long that I've been doing these regular posts on recent English, US, and sometimes decisions from other jurisdictions. But the idea was that I would get to know more lawyers. And here I am on your podcast. So I think it's been effective.
Yeah, pretty successful. I think one of the things that struck me about the engagement with those posts is that I find LinkedIn quite a difficult place for opinions really to be shared. I know it's supposed to be a kind of professional platform where people share opinions, but actually it can be quite a sort of defensive place where people don't want their opinions to be challenged. And I think there's something about the way that you post, which does a good job of fostering more kind of curiosity around the decisions and interest and discussion in a way that I've not really seen someone else who's managed to do that on LinkedIn. I'm not really sure what the secret sauce is, but it does seem that there's always a run of comments under everything that you post, where there's kind of healthy debate in a way, as opposed to defensiveness and this is what I think and I'm right.
Yes. I mean, I aim to approach recent cases in a spirit of curiosity, and I think that carries over into the comments. There can be some rather vehement opinions expressed in comments to my post, including on some of the issues that we'll talk about today, actually. But we can get to that later, I think.
Yeah, we've got a juicy topic to get into on the governing law of arbitration agreements, which I can't wait to get into, and to see that we've got the Supreme Court making comments one way and the Law Reform Commission and indeed Parliament kind of going another way. It's a fascinating issue to talk through, and really looking forward to getting into it. For those of our listeners who don't know Paul or haven't come across his posts on LinkedIn and other places, Paul McMahon is an associate professor of law at the LSE Law School. That's London School of Economics. He's the director of the executive LLM program there, and his primary interests are in contracts, commercial law, and international arbitration. I'm sure there's other stuff in there as well. And before working at the LSE, Paul taught at Harvard and Cambridge, and he's also got some US kind of flavor there in his experience, which is great to see. Member of the New York Bar, as well as obviously on the English law side, and he visits other universities and talks on these issues at various universities. So we're delighted to have Paul on. That English-US combination is really interesting for us. Our firm kind of covers both sides on the English and the US side. We're kind of set up to do both as well. So it's great to see that there's that dovetail with your experience as well. So perhaps if I just kind of open up with a broad one, Paul, if you want to tell us a bit about what you're interested in and what your focus is at LSE.
Yes, well, my primary area of interest for a long time was and still is really contracts. I teach commercial law, contract law, and most of the stuff I've written has been about those areas. But you mentioned my time in the US. When I was there, I studied civil procedure, and I got also really interested in litigation and dispute resolution. And so I was delighted when a couple of years ago I was able to take over the teaching of international commercial arbitration here at the LSE. And so now I really have two main areas of interest, which are contracts and international commercial arbitration. And of course, there's also an overlap there with conflicts of laws, private international law. And those are my main areas of concern. I've written mostly about contracts, but future work will focus more probably on arbitration. And one of the things I'm really interested in is the way that different jurisdictions are competing for dispute resolution business. So London likes to think of itself as a great capital for arbitration and litigation across the water. In Paris, they think they're pretty hot for arbitration. You've got to think about places like Geneva, New York, Hong Kong, Singapore. And that really is my future project. And one of the reasons that I've wanted to get to know more lawyers is that I want to get those cutting edge practical insights. What are people talking about? It's maybe not yet in the law reviews. So hopefully we can discuss that not only on this podcast, but on future occasions.
Do you find that this is an area which is particularly popular with students? It feels like international arbitration is going through a kind of real positive wave. A lot of people are interested in it. A lot of people seem to come out of university looking to move into that kind of work. That there's like the international element to it, the dispute resolution element to it. It's like, it seems like there gets a lot of interest right now. But I wonder if you see that even at kind of at student level.
Oh, very much so. I mean, my master's course on international commercial arbitration is heavily oversubscribed. If we put on an event here, we often bring lawyers in from outside to talk about international arbitration. That event will inevitably be extremely popular. We have a very international student body here at the LSE, certainly at the master's level, but also even at the undergraduate level. So we're also finding, I think this might be a slightly new thing, that the undergraduates are interested in arbitration as well. We teach them a little bit of arbitration in one of our courses, but I think we're not fully satisfying the appetite that now the undergraduates have. I think that is certainly a new development.
Yeah, it's interesting you raise this competition element around dispute resolution and what different jurisdictions can do to make their forum more attractive. And England obviously has a dominant position, has done for many years for a lot of reasons. I'd suggest predictability, certainty, the ability to grow with the law, case law kind of based progression and all of that. And that's a discussion topic in and of itself. But there are some real rivals coming to English law and London arbitration. And Calum and I spend quite a bit of time in Singapore seeing clients and what have you. And that's definitely taken off over in the East Asia, Singapore being a hub, Hong Kong not as much, but still it's another jurisdiction that attracts an increasing amount of international arbitration. And it's fascinating. We see we also have the US and the English dimension as well. And you touched on it just a moment ago that actually when you look at the court system between the US and England, they're quite different procedurally. Like that's actually one of the most kind of obvious differences between the two. I get that question. Like what's the difference between practicing in England and in the US? Well, actually civil procedure is a big factor in that. And do you think that factor plays into issues like what we're going to talk about today around, what should be how courts or Parliament should deal with the governing law of a contract and how to decide that question?
Well, certainly the Law Commission was persuaded by various London lawyers that the issue of governing law for arbitration agreements was something that should be addressed. And again, the explicit justification for the Law Commission's proposals was, let's make London or keep London great in the area of dispute resolution. So that's something that's strongly in the minds of policymakers, Ministry of Justice, and indeed the higher judiciary, from the commercial court up through the Court of Appeal to the Supreme Court. They're always talking about it. Now, I think there's a question about what really is the right thing to do from the perspective of attracting business and making your jurisdiction arbitration friendly, because people interpret that mandate in different ways. But certainly it is at the foremost of the front of the mind of many people involved in this litigation, as well as this legislative process too.
Yeah, I was going to say it is interesting because the different jurisdictions that you mentioned, they don't have the same approach in trying to make arbitration attractive in each of them. As you say, there are different ways that different jurisdictions try and make arbitration more attractive. And obviously, in the UK here, we're going through this process of updating the Arbitration Act, and we'll talk about that a little bit in this podcast. But it's quite rare, I would say, that you have a frustration with an arbitration process which is based around the kind of procedural statutory law. It's much more nuts and bolts and kind of are things moving quickly? Are parties kind of seeing good value in the institutions that they're arbitrating through? A lot of things that are on a more day-to-day, case-by-case level than the legislation on which the whole arbitration system sits.
Yeah, so it may be often a question of national arbitration law getting out of the way and allowing arbitrators to do the right thing. So, for example, the draft arbitration bill that's currently before Parliament, it facilitates summary determination in arbitration. Now, that's something that arbitrators, I think, could do. They didn't need that explicit legislative mandate, but it's probably a good idea to make it clear.
Yeah, and it's interesting from a practitioner's perspective because we handle international arbitration all over the world, and with co-counseling and having local lawyers appearing as co-counsel with you on international arbitration, there is this mindset, at least in that space, that there are ways of appearing on international arbitrations all over the world. It's when it gets into the court system that, from a practitioner's perspective, it gets more complicated. I suppose that's some of the issues around that play out in this case and some of the other related cases. We've talked about it a bit in abstract. Why don't I actually say what case we're here to talk about today? This is the recent UK Supreme Court decision in UniCredit Bank as the respondent and RusChemAlliance as the appellant. It is a judgment given on 18 September 2024, not that long ago. We had Lord Reid, President Lord Sales, Lord Leggett, Lord Burrows, and Lady Rose giving the decision. And as we've kind of alluded to, this case deals with the governing law. Primarily, there's two issues in the decision, but the primary issue I think that we'll talk about relates to the governing law of the arbitration agreement. And for those who practice in international arbitration will know about this all too well. For those of our listeners that are listening in without as much knowledge on international arbitration, one thing to keep in mind is that conceptually we have two agreements in these types of contracts. We have the main contract, which governs the substantive rights and obligations of the parties to that contract. Someone's buying something, someone's selling something. Here we're dealing with two contracts for the construction of LNG processing plants in Russia. And RusChem agreed to pay billions of dollars towards that. Those kind of substantive rights about payment and when payment has to be made and all those other substantive rights, they fall within the main contract. And then you have this other agreement, which I kind of am describing as a separate agreement. Often it's not very clear that it's a separate agreement. It sits in the main agreement. It's usually just one clause in the main contract, but it's an arbitration agreement. And it's a separable contract, if you like, or agreement that is between the two parties or number of parties to the contract, where they are agreeing to a dispute resolution process for any disputes that arise under the main contract. and that dispute resolution forum is an arbitration, so not in court, taking it outside national court systems and having it dealt with in a private sense by an appointed arbitrator or arbitrators. So that agreement to arbitrate is a separate agreement. And what we're looking at here is what is the governing law of that separate arbitration agreement. Is it the governing law of the main contract? Does it just flow through, or is it something else? And that there's a dichotomy built in there which we can flesh out a little bit more. Again, those who have been in this area will be aware of some recent cases on this. Enka is the big one, and a couple of others which we'll get into. This decision kind of follows on from Enka, looks back at Enka. It also, I think, is fascinating because, as Paul mentioned before, we've got the draft bill before Parliament dealing with this very issue. And we've now got a Supreme Court commenting on their prior decision on this issue, looking at the draft bill, and now deciding another case with this draft bill in existence. So it's all set up there. Calum, Paul, over to you to kind of flesh out some of the facts to this.
So I've got a question before we get into the facts. Question for both of you. Have you seen ever, or at least regularly, a arbitration agreement contained in the body of a normal commercial contract, where the arbitration agreement itself deals with this kind of in the agreement, in the heart of the agreement? I know that we can get into whether or not it's dealt with expressly by the governing law term in the substantive part of the agreement. But how often have you seen an arbitration clause that says this arbitration agreement has to be dealt with under, say, English law?
I'm happy to answer that from my perspective first, and then keen to hear what Paul says. I have seen it a couple of times, but when I say a couple of times, probably 2 times in 20 years of practice, looking at, 1,000 contracts or more. So I haven't seen it much. And it's just one of the kind of most obvious questions that comes out of this whole area of law is, why don't practitioners start structuring their arbitration agreements to make it bleedingly obvious what should be the governing law of the arbitration agreement as well as the main contract? There must be a practitioner's takeaway from all this. Anyway, what about you, Paul? Have you seen much provision?
I've never seen a real one, but the standard issue draft clauses from the Hong Kong institution, the HKIAC, they do have a blank space for the law governing the arbitration agreement. The other way that parties do specifically agree to the law governing the arbitration agreement is actually by signing up for LCIA rules, which now have a provision, I think, saying that unless otherwise stipulated, the law governing the law of the seat will govern the arbitration. So that would produce a different result from the one in this case, ultimately. So, but I'm aware through some of my LinkedIn discussions that lawyers, especially from England and Hong Kong and Singapore, are now pushing to specifically provide for this issue because of cases like this one where the issue has been highlighted. I suppose in many cases it doesn't matter. So if you choose an English seat and English law like that you'll have in many of your, for example, shipping cases, there's no doubt about the law governing the arbitration agreement. It's really where you're choosing arbitration in one place and the governing law from somewhere else. And I completely agree with you that at this point, it's time to make particular provision for this, because otherwise the answer is going to be unpredictable, because different jurisdictions around the world have completely different attitudes towards this question. So briefly, the main takeaway from the Enka decision is that the current English approach is that if you've got a governing law clause for the contract, the English courts will generally construe that to include the arbitration agreement. Even though the arbitration agreement is separable, from this perspective, the standard assumption is that the parties meant to make the same choice for the main agreement as for the arbitration agreement. But if you go to somewhere like Sweden, they have the opposite idea. They think that if you choose a seat, then by default, you mean the seat's law to govern the arbitration agreement, regardless of what you've chosen to resolve the merits. And so there's no consensus here around the world. Lord Leggett, who gives the main judgment in the UniCredit case, says it would be great if everyone could coalesce around a single result, but that's not possible. There's no consensus. The French have a completely different approach to this. They say that in international arbitration, you should apply international law to govern the arbitration agreement. What that really means is French ideas about what international law is. And then as a final approach to this question, under Swiss law, for a Swiss arbitration, whatever law will uphold the arbitration agreement, that's the one that applies. It's a very specifically pro-arbitration approach that the Swiss have. Anyway, so in theory, at least, all this could be solved through the exercise of party choice. And I think we will see it more often in future.
Yeah, I think the question needs to be on practitioners' minds if you're going to have different main substantive governing law to the seat. Like if you're going to have English law governing the main contract with the Paris seat, then you need to be thinking about this. Like there needs to be some consideration given as to what do you want the arbitration agreement to be governed by. I know you mentioned Sweden as being the opposite approach, but it's mentioned in this decision that the Netherlands, Japan, India, Australia, and even the Restatement Third in the US, they all go the same way as Enka. So there is a split here, but there is more weight. I think, at least according to this, and I've not gone through and researched on this extensively in other jurisdictions, but the Supreme Court, I think, here is implicitly saying, well, there are more countries out there that have followed Enka than have followed the Swedish approach.
There are, however, some very strong voices in international arbitration that say that the choice of a seat should be, by default, a choice of the accompanying governing law for the arbitration. In particular, Gary Bourne makes a very strong argument that the arbitration agreement is really a procedural contract, and as a result, it's intertwined with the arbitral law. And now, of course, the other thing that you've alluded to already is that we have a proposal from the Law Commission. It's now before Parliament. It's almost all the way through the House of Lords for English law to change from the Enka approach and to flip over and say that unless you have an express choice to the contrary, the law of the seat will govern the arbitration agreement. I'm just going to say, I can't get worked up about this debate. I can see arguments on both sides. And on both sides of this argument, there are people who get incredibly strident. You've chosen a governing law. Surely, of course, the natural meaning is that you mean to cover the arbitration clause too. And others who say, no, this is a completely wrong way to think about it, and it upsets party intentions. I think parties just don't have any intentions either way. What we need is a clear default rule. Right. And it probably doesn't matter which one, you know.
When you're reading through this this judgment, and indeed Enka, and indeed most of them, it's pretty obvious that the parties didn't really think about this at the time of entering into the contract. Because if they did, they might have dealt with it in the arbitration agreement itself. You know, but if you've thought carefully, like in the Kopatsky case. If you've thought carefully about whether or not you want Swedish law to be the law that governs the arbitration agreement, then rather than leaving this slightly curious open point up to the interpretation of different courts, you could just put Swedish law shall govern this arbitration agreement in the contract. So the reality is, I think that commercial parties are extremely unlikely to think about this. Probably, similarly to you. It would almost depend which way the wind is blowing, whether the party said, well, we agreed to have an arbitration in Hong Kong, and therefore Hong Kong law should govern the arbitration agreement, or they said, well, we agreed that the substance of the dispute was English law, and therefore English law should govern the arbitration agreement. And I think it's a really interesting argument for lawyers, and it can have a huge effect on the commercial agreement for commercial parties. But fundamentally, it's one of these points which is probably more interesting to argue or to talk about than it actually has a huge difference on the commercial landscape.
I completely agree with you guys. I think that's right. Now there's a scale here, isn't there, of contracts and where consideration will be given to these types of matters, and maybe in $1 billion LNG contract, they will consider in some detail what's going to be the procedural law of the arbitration, and that's why they chose Paris. I can safely say, though, in many commercial contracts, even the choice of seat is as straightforward as thinking, where are we going to sit and have this arbitration? I would suggest, and I say this with quite a bit of confidence, that many commercial parties out there, maybe in the commodity space, the shipping space, would not be sitting there thinking, if I put Paris as the seat of the arbitration, that means that the procedural law, curial law of France, is going to govern the procedure of this arbitration.
I think you see this now with a lot of our clients, where you have clients in the world of international trade, where they may want English law to still apply, but for various reasons, you don't have to look particularly hard at the sanctions landscape over the last few years. And they may increasingly say, well, we would like any disputes to be heard in Hong Kong because we don't want to travel to London. We still want English law, but we want the disputes to be heard in Hong Kong because we're more comfortable traveling to Hong Kong. I don't think they're necessarily saying we would like or I don't think they're necessarily intending. What we really want is the curial law of Hong Kong to apply to our dispute resolution process, or indeed we want the law of Hong Kong to apply to the interpretation of this arbitration agreement. I think they're fundamentally saying we would prefer to get on a plane that's going to Hong Kong than a plane that's going to London.
Yeah, and yet this turns out to be absolutely crucial in the case of UniCredit and RusChem. So in this case, which is about performance bonds issued by UniCredit in favor of RusChem, to the tune of about 440 million euros. All 7 bonds have the same clauses concerning disputes. They say that this bond and all non-contractual or other obligations arising out of or in connection with it shall be construed under and governed by English law. And then the parties say, we're going to choose arbitration before the ICC, and the place of arbitration will be Paris. Now, why they chose that? Did they really have in mind that the legal place of arbitration would be Paris? It may be, of course, the ICC is headquartered in Paris. There's an association between the ICC and Paris, which is not one you have to draw. But regardless, then that turns out to be essential. This combination of clauses turns out to be essential in this case. Because, of course, what happens is that the EU imposes sanctions on Russia after the contract's concluded, and RusChem says we want to claim on the performance bonds, and UniCredit says something like, well, we'd love to pay you, but we can't. Our hands are tied by sanctions. RusChem's not actually on the sanctions list, but it is ultimately largely owned by the Russian government, so you can see the issue there. And RusChem, of course, what they're supposed to do now is commence arbitration in Paris, like they agreed to, but they don't do that. They go instead to the Russian courts. And why is that? Well, there is a Russian law that says in any dispute between Russians and foreigners involving sanctions, the Russian courts have jurisdiction. And it doesn't matter if there's an arbitration clause choosing another form of dispute resolution. And UniCredit, of course, doesn't really want to be in the Russian courts. You don't have to be a litigation strategy genius to understand that. They'd rather be in arbitration in Paris. But they did not choose a place of arbitration that readily issues what they want now, which is an anti-suit injunction, right? So I think you're absolutely right. The parties probably didn't give much thought to this, but if what you want is an anti-suit injunction, the French courts are not the right place to go because they basically don't issue them. Now, one case where the French courts issued an anti-suit injunction, but generally they don't do this, and it's very clear in this case that the French courts wouldn't have jurisdiction. So that's why UniCredit, in seeking to stop this Russian litigation, ends up going to the English courts. And it's why we're having this debate about the law governing the arbitration agreement. And that's how we got into this issue, which, as you say, the parties probably never thought about at the time of the contracts.
Yeah, it's fascinating. It's fascinating. We've seen quite a few cases coming out of the sanctions landscape, if I can put it like that, and some of these types of jurisdictional debates, sanctions debates, and then how the sanction-related matters then affect the substantive rights of the parties. I like, just as a little aside, and I thought that was a great summary, if you don't mind me saying, Paul, but as a little aside, I like the comment there that the court gave when they noted that Lord Reed, PSC, has formally expressed this court's gratitude to Judge Saltykova for taking this course, that is, staying the proceedings and enabling these proceedings to be dealt with in an orderly way. I thought that language towards a Russian government official on the judiciary is quite cordial compared to some of the other language that's been floating around towards the Russian government recently.
Yes, well, the language is cordial, but the ultimate result is, in a sense, anything but, right? Because what the court ends up doing is enjoining RusChem from proceeding in the Russian courts. And so, look, now we simply have a conflict. The Russian courts will issue all the interim relief and freezing orders against UniCredit that RusChem is asking for, and likewise, we've got the English courts ultimately seeking to enjoin this litigation. Whether that's effective or not, I'm not sure. But so the difficulty here again is that UniCredit is, in a sense, not in the natural place to get help in an arbitration. Naturally, you go to the courts of the seat. And this case would have been extremely easy if the contract had said that London was a seat of arbitration. And it's almost routine now, I think, for English courts to issue anti-suit injunctions to protect English arbitration and also English exclusive jurisdiction clauses. And the question, and there are two questions in this case, but in a sense, they both boil down to, what do the English courts think they're doing getting involved in this dispute? Why is this the business of the English courts? And the question is a jurisdictional question. And of course, the way that the traditional common law approach to service outside the jurisdiction works is that you have to get the court's permission to take the claim form and serve it on the party who cannot be found in England and Wales. RusChem cannot be found in England and Wales. So you've got to do that. So you have to show the court three things. First, that there is a serious issue to be tried on the merits. No real difficulty with that here. The English courts are strong on the view that RusChem is violating the arbitration agreement and, in principle, should be restrained from doing so. But the other two elements of the test for service out are very much in question here. The second question is there a good arguable case that one of the gateways in the civil procedure rules is satisfied? And the second one is, even if one of the gateways is satisfied, is England and Wales the proper place for this claim? So those two issues, gateway and proper place, both get a huge amount of discussion in Lord Legate's opinion. And ultimately, of course, he, backed up by all the other Supreme Court justices, find that one of the gateways is satisfied and that England and Wales is the proper place. But again, the real question is, why the English courts? So on the gateway issue, you cannot just go to an English court and say, please act. There has to be some connection between the defendant and the jurisdiction or the claim in the jurisdiction. And here, the only possible link between this case and England and Wales is the governing law. Now, it has to be, I think, the governing law for the arbitration agreement, because that's the claim that is being brought here, a claim to enforce the arbitration agreement. And so that's why we get into this issue that we've talked about a lot already, which is what is the law governing the arbitration agreement? Look, if you look at Enka, at first glance, it seems this is very easy. The parties have chosen English governing law. That usually will govern the arbitration agreement. But the difficulty here is that there was a caveat in the Enka decision. There was a potential exception given in the judgment of Lords Hamlin and Leggett. And that exception was, well, what if the parties have chosen, alongside a governing law clause, a seat of arbitration, and the seat takes the position that when you choose our seat, our law should govern the arbitration agreement. And that was the argument that RusChem was running here, to say, no, the English law doesn't govern the arbitration agreement. French law does. And that's why this caveat came in. And when I first saw this case, I thought this is a very easy case, but actually the caveat is there. It wasn't applied in another case that was between Enka and this one, which is Kebabji and Cout Foods, another very important case, where the parties again had chosen English governing law and Paris arbitration. I guess it wasn't raised in that case, but potentially it does apply. And that was, RusChem's main argument against one of the gateways in the CPR being satisfied. And in fact, they persuaded the High Court judge in this case that actually French law governed the arbitration agreement. But in the Court of Appeal, another view was taken by your favorite Lord Justice of Appeal and mine, Lord Justice Males. And again, yes, I have. And that's the view that prevailed here. So the interesting thing is that there's a question of whether French law really takes that position. In the end, Lord Leggett says, look, why don't we just dispense with this caveat, this exception? It will be much cleaner and clearer if we just say that doesn't matter. And of course, one of the criticisms of the Enka decision was it created uncertainty. I think this case removes some of that uncertainty by removing this caveat and by saying, we said that maybe that was the case in Enka, but let's forget about that now. If you choose an English governing law or any governing law for the contract in general, then it will again generally be construed to cover the arbitration agreement as well. And that's why in the end, the Supreme Court said in this case that English law governed the arbitration agreement. And that is enough to pass through one of the gateways in the CPR.
Yeah, fascinating. Look, for those who want to look at it quite closely, this is at paragraph 33 of the judgment. And there's a summary there of the Enka principles. And the caveat that Paul's talking about here, first, it's got Roman 4 there, where the law applicable to the arbitration agreement is not specified. A choice of governing law for the contract will generally apply to an arbitration agreement, which forms part of the contract. So, in other words, governing law of the main contract, the substantive rights, that will generally apply to the arbitration agreement, which is another clause sitting within that main contract. Second point. The choice of a different country as the seat of the arbitration is not, without more, sufficient to negate an inference that a choice of law to govern the contract was intended to apply to the arbitration agreement. So, in other words, as we have here, the nomination of Paris as the seat of the arbitration is not sufficient enough to negate the inference that the main contract governing law provision will apply to the arbitration agreement. But then we come on to this third point here, and this is where this is the caveat that we're focused on in this case that Paul was referring to. additional factors which may, however, negate such an inference and may, in some cases, imply that the arbitration agreement was intended to be governed by the law of the seat are, and we've got an A and B here, A, any provision of the law of the seat which indicates that where an arbitration is subject to that law, the arbitration agreement will be treated as governed by that country's law. And then there's B, the existence of a serious risk. We're not dealing with that second point, serious risk, that if governed by the same law as the main contract, the arbitration agreement would be ineffective. That's not the focus of this provision. It's this A, any provision of the law of the seat which indicates that where an arbitration is subject to that law, the arbitration agreement will also be treated as governed by that country's law. And that's what we're exploring. And what the parties were debating here and what RusChem was trying to argue is that when you go and look at French law leads you on an inquiry that gets you to, even though it refers to international arbitration rules and, in the French approach, which is quite a fascinating topic and one anyone who's interested in arbitration law, I strongly encourage you to get into it and look at it in some detail and look at how the French approach sits with the English approach. It's historical. It goes to, philosophies on arbitration and what have you. But that's not a discussion for today. But when you go through this inquiry through the French law, you end up with the result that French law will say the law of the seat should govern the arbitration agreement. And there's quite a few hoops that you have to jump through to go down that route. And what the court here is looking at is we're talking about inferences, like negating such an inference that the governing law of the main contract should also apply to the arbitration agreement. Are the parties really intending that you have to go to French law and then from French law into international arbitration law under that law, and then go through almost like a conflict of law analysis over in that law to then work out what is under that law the governing law of the arbitration agreement? And these kind of jumps, if you like, that you have to make to go through that process to work out the party's intention, I think was a real stumbling block here for the Supreme Court.
Well, you've got the starting point really is because there was this quite funny section in the judgment where they talk about whether it's implied that the law of the arbitration agreement
implied or express choice.
Exactly.
Yeah.
They're almost telling off commentators who have said it's implied. I never said that. And really what they're saying is it's an express choice. Where you have a governing law in the agreement, then you can assume that that's the express choice for all of the agreement. And it goes to what you're saying. Like, do you then basically have contrary indications that mean that as a process of construction, you should say that there's a different intention for a certain governing law to apply to this arbitration agreement, or does it simply borrow its law from the governing law clause, which is intended to apply to all of the clauses in the agreement? And you can then take the arbitration agreement itself as being subject to that governing law clause. I think that there are some people who feel that slightly offends the principles of separability that the governing law contract for the substantive the governing law for the substantive contract would bleed into the separate arbitration agreement. I think in practical terms, probably the intention of the parties is that it would be supposed to. But yeah, then as you say, you're looking for something which really has to be quite strong to give a contraindication. And in a way, this judgment almost felt like the Supreme Court is saying, well, we sort of left the door ajar there in Enka and Chubb, and we'd like to kind of push that door closed a little bit now and say you need something a lot stronger than just a seat that says that the seat applies its own law for the governing law of the arbitration agreement. Because otherwise, every time you have this dispute, you're off to the races looking at the law in the place of the seat as well, and it becomes pretty unwieldy. It's funny that you say, Paul, that they this judgment kind of at last gives us certainty on this point, only for the arbitration bill to come in and likely overturn the position.
Yes. I think the Arbitration Act provision also provides certainty. I know there have been some commentators who think it doesn't, but it seems pretty clear to me what will be Section 6A of the Arbitration Act. It'll say that unless you have an express agreement to the contrary, that the seat's law will govern the arbitration agreement. Again, I just can't get too worked up about this. I think certainty either way is probably a good thing here. Probably the law would have been fine if the Law Commission had left it well alone. And again, because you can provide certainty with statute, but you can also provide certainty over time as judges develop the law and give it precision. So look, it may be that we're talking about this decision that soon it'll be obsolete. But so be it. I'm still enjoying it.
Yeah, it's still a very interesting discussion. It's interesting that we've had kind of 3 of these in the last 4 or 5 years, where it's just come through. And I wonder if that is a little bit as well about popularity, and demonstrates something about the popularity of international arbitration, but also the slightly more complex international landscape, where this issue really arises in this case, specifically in this case, because of the issues in Russia. There's a really the whole dispute, the broader dispute, not dispute on the arbitration points. The broader dispute really comes about because you have this international instability, and I do wonder whether that international instability globally is causing more of these issues to kind of bubble up to the surface.
And I think you're right, Paul. Ultimately, it's the parties want certainty on this, particularly if it's not an issue that they're actively considering at the time of entering into these contracts, which I think in most instances is right. But what I really enjoyed about this judgment is the kind of separation of powers between judiciary and parliament. And the court here is very careful to say, well, this is how we see the law. We wrote the original Enka decision for these reasons. We did consider, and these aren't the words that the court's using, it's my paraphrasing, I mean it with respect, but the courts are saying we did look at whether it should be the law of England that the seat selection governs the law for the arbitration agreement. And they make the point in this decision that is not as that is not as straightforward as it appears, and that then can lead to an inquiry into whatever the law is in a seat, and a debate being brought up on what is the law of the seat to govern the arbitration agreement. And there's kind of the point being made here that it's not as straightforward as it seems, and they had considered that. And they ultimately decided that the parties are making a clear choice as to what law should govern the contract, and why should the arbitration agreement be treated any differently to any other clause in the contract. And from just a personal perspective, I know it's a debate that, so what, I get your point, but from a theoretical perspective, I've got to say I have a lot of I'm on the side of the Supreme Court on this one. I think the parties are making a choice as to what law governs the contract. And if there's only one sentence in that contract that says the parties say that English law governs the whole contract, that's every part of that contract. And I think it is a stretch to say that selecting a seat means that the arbitration agreement should be governed by the seat law. So that said, the court is also, so there's kind of this undercurrent of, well, we did consider it, our view was that this is the right approach, but the Law Reform Commission have gone on to say something differently. We're going to stick to our guns here and make it clear that we, I don't know, they put a lot of work into their original decision, right? And they came up with a view here.
They did.
Yeah. So
they did, but can I add that having come up with the Enka approach, Lords Hamden and Leggett made a personal submission to the Law Commission suggesting a change in the law. What they wanted to say was, if you choose England as the seat, then English law should govern the arbitration agreement, which is a pretty blatantly pro-England approach, maybe one they didn't feel they could adopt as a matter of judicial development of the law, but as a matter of policy, they actually suggested that. So there's all kinds of complexity and differing views here. But the funny thing, of course, is that under the new law, if and when it becomes effective, the result of this case is different, right? There will be no gateway for UniCredit to pass through. An English courts pretty clearly wouldn't have jurisdiction in this case, and the English courts wouldn't be able to restrain the Russian litigation. There's a slight possibility. You see that UniCredit tried to argue that it would be enough, the law governing the merits of the arbitration, but they raised that way too late in a footnote. I don't think that's going to work anyway, which is why they didn't make the argument in the first place. So unintended consequences, I think, of the arbitration bill would be that the English courts couldn't hear this case.
Yeah, I think instinctively between the two, I'm more on the side of, as you say, like I feel like the governing law of the whole contract would also be intended to be the governing law of the arbitration agreement, absent these other indications. But I can see both arguments. I mean, I think the argument which is kind of raised and then shot down in the Supreme Court judgment is this overlap argument that effectively the curial law, which follows the seat, is so closely connected to the law of the arbitration agreement itself that one should be the other. And they say, that's a fair argument, but it's wrong. And it's wrong because they look at things like I guess when you're exploring the law of the arbitration agreement, you're thinking about things like the validity of the arbitration agreement and the effect of the arbitration agreement. Whereas when you're looking at curial law, you're looking more at the arbitral process. And they say you can basically draw that distinction between the two. So we don't need to be too worried about this overlap. Whereas I think, as you've said, Paul, some of the commentators are a bit more worried about that overlap, and they are perhaps more concerned as well about a different overlap, which is an overlap of a governing law clause for substantive for contract one bleeding into contract two being the separate arbitration agreement.
Yeah, but my last point on that was that the court was very clear to then go on and say, well, because this is a pending bill before Parliament and you've had the Law Reform Commission look into it, this is now very much within the realms of policy. And we are going to restate what the current law is and follow that in this decision. So following the Enka decision and Kababji and maintain that position. We're not going to almost relitigate these issues again while this matter is before Parliament. And if anything, they saw it as a reason not to entertain an argument that Enka was wrongly decided on some basis or not completely didn't complete every issue because it is before Parliament. And you can see then that kind of coming full circle to where we started in this discussion, there are policy-related issues in this, right? If England wants to promote itself as a leading dispute resolution forum place, promote London arbitration, these types of considerations come into that. There's factors that go into this kind of rule that are political and not necessarily just legal. Of course, there are legal arguments as well, and there's all sorts of points that have been put in the submissions for the Law Reform Commission. But you can see why a court, doesn't want to kind of go that distance and get into more of the kind of political discussion.
I agree with you. I just don't know which way they go. I don't know whether it actually suits England as an arbitration venue. As in, will England have more arbitration work, more kind of money going through the arbitration system if it says the law of the law of the arbitration agreement is the law of the seat, or if it says the law of the arbitration agreement is the governing law? I would say probably slightly more if you go towards the governing law.
Well, I mean, if you're really thinking about this, consideration, if this is really affecting your choice of a seat of arbitration, you could simply specify it in your clause. Again, I think we are imagining a level of sophistication and time devoted to these issues that probably isn't there. But to talk about the political issues, I think, before we run out of time, I really do want to talk about the second big issue that the Supreme Court had in this case, which is the proper place. So having decided that there is a gateway here, you still have to ask whether England and Wales is the proper place for this claim for an anti-suit injunction. And what I thought was really interesting was that Lord Leggett kind of disagreed with both parties' ways of approaching this case, with this aspect of the analysis, because both parties had said, well, let's use the framework from the Spiliata case, which is the most famous English case on form non-conveniens and proper place. And in that case, Lord Gough set forth an approach where you're weighing different factors. Spiliata was a tort case that could have been heard in England or maybe in Canada on the merits. And it was a sort of weigh it in the balance type inquiry. But what Lord Leggett says is this case is nothing like that, right? This is not a case where someone's saying England and Wales is the proper place for the merits, right? The two possible places for the merits are Russian courts and arbitration in Paris. So we don't need to worry as an English court here about usurping the proper place for the merits, which according to the Supreme Court is very clearly arbitration in Paris. What we're doing here is piling on in favor of a different forum, and that calls for a different analysis. And it calls for an analysis that's more like the kind of analysis courts undertake when they're asked to stay litigation before themselves or to issue an order in favor of English arbitration litigation. And what the overwhelming vibe you get from the second part of Lord Leggett's judgment is, look, the arbitration agreement is a contract. We should not feel embarrassed about enforcing that contract. That is a very strong feeling you get here. And so really there are very few qualms on the part of Lord Leggett about issuing the injunction. And I wanted to hear what you thought about that.
Yeah, I think it's very practical, isn't it? It's almost, as you sometimes see with judgments that the court knows the right result and they want to make sure that they get to the right result. And here it's, once you've made your peace with the fact that this is a English law governed arbitration agreement, I think that Leggett's very, very quick to say that obviously this is the right place for it to be brought, because we're not stepping on anyone's toes. We're doing the opposite, really. We're putting the arbitration in a position to be conducted in accordance with how it was intended to happen. And I think the background is significant in that you have Russia, which is a signatory to the New York Convention, basically disregarding the New York Convention, as you mentioned earlier in the podcast, they've got this legislation now that effectively says we take jurisdiction in any arbitration where there are sanctions issues. So I think that it was very clear that the sensible decision here is, yes, the English court is the right place to bring this. More than anything, because the English court is going to give effect to the right outcome. And I think it's sometimes difficult for the court to put it in terms that are that straightforward. But 9 times out of 10, you see that you do see the English court apply things in a way which is sensible, and then the law kind of helps them along the way.
Now, there were, however, I think different ways to reach this result. There was, I think, a narrower way of doing it than what Lord Leggett said. So what the Supreme Court could have said in this case is there's really no alternative forum here that will give UniCredit what it deserves. The French courts don't have jurisdiction. They generally just don't do anti-suit injunctions, so we need to step in. But if you look closely at what Lord Leggett says, he's saying that's not required. And if you look at paragraph 104 of the judgment in particular, he's saying, look, it wouldn't really matter if the French courts had jurisdiction. We would do this anyway. And so I think it's a more resounding victory for the arbitration agreement than was absolutely necessary. And that's what I find interesting. And so, I said before, I teach contracts. And I also teach international arbitration and private international law sometimes. And with my contracts hat on, I think, yeah, go enforce the contract. But people who come at this from a private international law background, I think, have more concerns about this. There's a worry that, England is being this sort of global policeman for arbitration. And there have been a few comments to that effect from other colleagues in the academy, again, who are more on the private international law side. And I think I am in two minds over this. There's something to be said here for the fact that the English connection to this dispute is actually pretty tenuous, right? Oh, the governing law for the arbitration agreement is English law. Well, that's not a basis for personal jurisdiction in other legal systems that I'm aware of. Like, that's not enough for jurisdiction under the Brussels recast regulation for the EU. Wouldn't be enough to assert jurisdiction in a US court over a defendant, right? It's quite a slim toehold. And so the English interest is, it's pretty weak. Now, it seems, however, that the Supreme Court thinks, well, these are English law rights, and there's a sort of parental or maybe grand parental concern for these kinds of rights, and so we need to see that they're enforced.
Yeah, it's interesting. It's interesting because as I say, there is this narrow approach that works for this case and probably works in the future for French seated arbitration, but then doesn't work for a lot of other different seated arbitration where you would be able to go to.
Right. So other common law jurisdictions, you go to Hong Kong or New York or something, right? Yeah.
There's a sense that you can take a case like this and if you wanted to, you could kind of expand your ambit on a case like this and say, you can use a case where you're kind of firmly in the right, doing the right thing to give yourself a little bit more power in the kind of world police example that you use, and no one really bats an eye because you get to the right result, but then the judgment sits there and you can go back and refer to it next time there's a kind of, as you say, a case in a different common law jurisdiction. I can see why there's some concern maybe worldwide for that. I guess the answer, the way that Leggett puts it is, well, we're not saying that we've got jurisdiction over this claim. We're saying that we've got jurisdiction, over the arbitration claim. Basically dealing with the arbitration claim form and the claim in that arbitration, which is one for this injunctive relief, and saying we can deal with that bit because of the governing law. We're not going to tell you who owes what under these performance bonds. We're just going to tell you that we can deal with this arbitration claim.
Would it kind of come across differently if the parties had just written into their contract that the arbitration agreement was governed by English law? Like, I know it doesn't change it legally because it's the same result, but I mean conceptually. I mean, if on your point about is it a strong enough toehold, if the parties had clearly, very expressly said, okay, we want an arbitration agreement. It's got a Paris seat, but the law of this arbitration agreement is English law. It's all stated there nicely, pretty with a bow on it. To me, it kind of, I can see why an English court would be like, yeah, okay, I'm willing to go that far.
I think that would strengthen the case.
What about?
But I mean, it's obviously not necessary according to the English courts.
My point in making it that clear is that that's what the courts have done here, right? By following Enka, they have effectively said that is what the parties have done here. And I think if you look at it like that, it does seem like a stronger toehold.
What about if you put you have the standard LMAA clause, because the LMAA has similar wording in its rules. It says if you go for LMAA arbitration, absent anything to the contrary, your arbitration agreement is governed by English law. You're kind of one step removed from your example, Luke, right? Where if you have in your example, it's very clear that there's this intention for a governing law, the governing law of the arbitration agreement to be English law. You then got step one removed, which is that you're incorporating terms which make it very clear that that's the intention. And then I guess step two removed is that you're just relying on the fact that English law will treat it as being, for about 5 minutes before the legislation comes in, will treat it as being the law of the governing law of the contract. I'm not sure where. I guess my point would be, I'm not sure whether there's any point in that journey where it becomes more or less of a toehold. It's if the governing law is English law, and the court says, well, we'll take that as enough for us to kind of give effect to the arbitration agreement wherever the arbitration is happening, I think they're happy applying it anywhere.
I think the upshot for me, Calum, is that I'm just too ingrained into the English practice, and if there's a way of getting it into an English court and arguing that, I'll probably go that way. Although if I was instructed on the other side, I'd find pretty good reasons to argue otherwise.
But it's interesting we're talking about the global market for law here. I mean, really, London is giving away a service for free here, right? Because it's helping out Paris arbitration. Yes, of course, London lawyers did get paid quite a lot to litigate the anti-suit injunction, but it's providing a service for parties who in a sense, snubbed London as the seat of arbitration and went for Paris, and then came crying to the English courts. That's a somewhat ironic situation, I think.
I like that. I think that's a nice place to wrap it up, Paul. I like that point. Any other final thoughts?
One thing I wanted to mention is, what are the implications of this decision for anti-suit injunctions in favor of foreign choice of court agreement? It would seem the logic of Lord Legate's decision would be that likewise, that an English court would issue an anti-suit injunction in favor of foreign litigation. He does lean on the New York Convention, which doesn't yet really have a full analog in the choice of court space, but it would seem to also, we'll see that case come up in a couple of years' time, perhaps, but it's an interesting potential implication.
So this would be an English law governed foreign court jurisdiction contract.
Yeah. I mean, of course, there has to be some sort of jurisdictional hook. Indeed, whatever it is, might be that, it might be something else.
No, that's interesting. I guess
that is an interesting point. I wonder how often that would come up, but yeah, it is.
Well, I guess it's like you say, Luke. You might have some lawyers who think it's quite nice to run these things in England, and you do. There is a large degree of certainty in the English law around anti-suit injunctions. You do sort of know what you're getting there. So it may be that parties feel like if they have to go for an anti-suit injunction, if there's some way of doing that in England, some jurisdictional hook, which, as you say, Paul, it might not be that the governing law is English law, it might be any other jurisdictional hook. It may be that the parties think that actually the English courts could be a good place to go to prevent the Brazilian courts from taking over a Indian claim. You can.
Yeah, I see that. Fascinating. Well, look, Paul, I've really enjoyed this discussion. Thank you very much for your time, a generous amount of time too. And for your considered insights. I'm sure it won't be our last discussion on some of these types of cases, but thanks again.
Thank you.
Really appreciate it, Paul. Really enjoyed it.
Yeah, and to our listeners who have come with us, I hope you've enjoyed today's episode. Thank you for listening in, and of course, we really appreciate it if you do the usual, like, subscribe, all that good stuff. Do look Paul up on LinkedIn and other places where he appears, and you can follow along some of his insights there. Until next time, take care. Thank you, everyone.
Yeah, and I can't recommend enough following Paul on LinkedIn. I have clients who will send me screenshots of Paul's case notes, and usually I've read the case, so I'm in a position to actually contribute something meaningful. But certainly following Paul on LinkedIn will keep you on your toes.
Good stuff. All right.